Hey everyone, welcome back to the channel. In today's video, we're taking a look at 3 sovereign citizens appearing in court. First up is a sovereign citizen squatter in Judge Simpson's courtroom, attempting to push the common sovereign citizen real estate scam that claims you can live on a property forever without paying rent. On a quick personal note, I'm currently in Turkey undergoing extensive dental treatment. Earlier today, I had 8 root canals done, so there may be fewer interruptions than usual in this video. Over the coming week, while I finish this dental work, a few fellow content creators will also be stopping by the channel to share videos. Thanks so much for your patience and support. Let's get started.
Oh,
Thank you, Your Honor.
Thank you.
why?
They're on their signs.
No, I'm going to give it to Lee. Why are you appearing here?
You told me to put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Defendant.
Okay.
Yeah.
Thank you. Court does call the case of VMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, John.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No,
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending But the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that.
If you're ever trying to spot proof that sovereign citizens actually exist, you might start by checking the melted crayon buffet, where they seem to gather for lunch. What we're seeing here is a classic sovereign citizen tactic, and it's outright fraud. Of course, it only becomes fraud when the court has authority, something she conveniently denies until recognizing that authority
Has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous.
I'd be anxious as well if I were on the verge of losing my home because my little mortgage fraud fantasy was completely unraveling. There is a simple, non-medical solution to that anxiety, though. It's called paying your mortgage like everyone else.
But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you
rights.
are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Miss
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part uh, that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
I absolutely love Judge Simpson. He basically said, "Oh, you're asking for a $10,000 a month appeal bond. Cute. Let me bump that up to $15,000. What that means is simple. Unless these sovereign citizens can come up with roughly a year's worth of their income, they're out immediately." And that wasn't even the end of it, because Judge Simpson had a few more choice words before moving on to the next case.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
See what I'm talking about? Judge Simpson doesn't play around. Next, we move on to another hearing from a few weeks back. This one in Judge Shackelford's courtroom. The matter was heard by a temporary judge, also called a judge pro tem, and even when the judge is filling in, it's hard not to find the humor when a sovereign citizen strolls in and hands the
Hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
All right.
No, you really don't. The rights you think you have are rooted in a made-up legal fantasy that only makes sense if you've been marinating in nonsense for far too long. And let's be clear, any attorney who's passed the bar already understands exactly why your legal beliefs fall apart. There's zero chance a real lawyer is going to torch their reputation, let alone risk the license they worked years to earn, just to indulge this level of foolishness in a real court.
Right. Good morning. I'm Judge Chungan. We are here on people of the city of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James
Mr.
Kazicki. I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not, support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you have.
Well, I understand my rights.
Would you look at that? He actually showed up in court today. We might end up with a bonus segment on my Team Skeptic After Dark channel, so you'll probably want to check over there once this video wraps up to see if it's already been posted.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Guzicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You'll plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pre-trial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir. So in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until the jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf, and you could testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example, prosecutor could never tell the jury that, oh, you must be guilty because you didn't testify. We don't allow that, sir. The people have to prove you're guilty, your guilt beyond a reasonable doubt. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So where you're going to meet with an attorney here in the court. You write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9 a.m. All right. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m.
Why don't you do society a favor and hold your breath until someone agrees to pay you for the behavior that landed you in court today? And just like every other judge who's been threatened with one of these laughable fee schedules, this pro tem judge is completely unfazed as well.
All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, you can't be sent to jail for these. They're simply not criminal offenses. All right. You'd be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, you've stood mute. I'm going to note you're requesting appointed counsel. I'm also noting for the record, you had spoken with Mr. Kazicki, and he's not able to represent you any further. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again. You come back on July 16th in court for a pretrial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part, but what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
All right, that wraps up video number 2. As mentioned earlier, be sure to check out my second channel, Team Skeptic After Dark, to see if there are any follow-up updates tied to this case. Now we move on to Thurston County, where we see the return of a sovereign citizen that a surprising number of viewers previously felt sorry for. He claimed there was a massive local government conspiracy aimed at silencing him, and plenty of commenters insisted he wasn't actually a sovereign citizen at all. Unfortunately for them, they were mistaken, and I don't exactly feel bad about it. In this video, he drops the act entirely and goes full mask off, diving headfirst.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
You don't have to be happy about it, but unless you personally constructed the roads you're driving on, and they sit on your own private land, you're part of a social agreement the rest of us have accepted. The second you shift your totally not a car into drive instead of park, you'd better have a valid driver's license, or you're going to deal with the consequences that come with breaking the law.
I didn't come prepared to contest the infractions.
Well, that'll be easy because you can tell me whether you have insurance or not, but hold on a second.
Sure.
Let me just explain. Failure to transfer title, the trip permit, and the driving suspended charges, which are all criminal charges. And those are the ones that you'd filed all the pleadings on, which I've read all your pleadings.
Okay. You have any comments on it? Just curious.
I'll give you my comments here in a moment. So, without ruling on anything that might be filed on the new case, I'll just share some thoughts with you, which are that the view that you set forth in your pleadings is, we see that occasionally, very similar language. I don't know, sometimes the briefs we get in this line are all read the exact same. Yours is not the exact same, but a lot of exact same. there is no case in the country that says the state cannot regulate the driving, both commercial and private, on any public thoroughfare. So, you know, I read your arguments as to why you believe the freedom of travel means you can drive your private vehicle on public roads, which are paid for by the registration of the vehicle, by the way, in part. That you believe you can drive because you have the constitutional right to travel. That it's never been interpreted that way. So the constitutional right to travel does not apply to overcome the requirements that states have imposed to require you to register your vehicle on an annual basis. That is it. I pay my registration fees every year because I have to, in order, if I want to put my car on the road. And I know if I put my car on the road with expired tabs, I'm going to get stopped and I'll have to pay the fine and I'll have to go get my car tabbed. I just know that's the way it works. And that's how the system is set up. So there's no legal argument there. You know, you made it in a sort of a big way, but I think it's a misinterpretation of what you believe the right to travel is. It does not give you the right to travel in any state not adhering to that state's laws, and every state has a registration law like the state of Washington. So you've asked for my general.
Have you noticed that in courts, a car is referred to as a motor vehicle? A friend riding with you in the car is referred to as a passenger. You're engaged in traffic, and what the problem is, when a person registers his private property automobile with the state, he's declaring it a commercial vehicle.
No, that's your interpretation, and I'll just tell you that's not the interpretation shared by the courts. We don't see it that way at all. So the law makes very clear that all of us who have vehicles that we put on our roads, they have to be registered. Doesn't matter whether we have passengers, no passengers, if we drive them ourselves or not, if we're engaged solely in personal business or moving from point A to point B, none of that exempts us from the requirement to appropriately register our vehicles, which is used as a means of supporting the construction of the roads that we drive on.
Yeah, you know what? You said you've seen a few of these. What compels people to do this is the state abusing its power to license drivers, as well as doctors and other professionals. If you don't behave the way the state wants you to in your private life, in your family life, the state, through the family court, can have your license suspended. And that's just strong evidence that the system is not set up to make the road safe, but to control people. And people don't like.
Okay, it looks like we've got another court date coming up with him, where he's going to have to figure out how to navigate the deep end of the legal system, without much in the way of tools or sense. Thanks so much for watching, everyone. Like I mentioned, over the next week, a few guest content creators will be dropping videos on my channel to help keep things rolling while I finish up my dental work. I really hope you enjoy their content as much as I do. In the meantime, if you liked the video, give it a thumbs up. If not, hit dislike, but make sure to leave a comment, subscribe, and turn on notifications so you don't miss any future.
The philosophy behind that. We don't do anything here with suspending licenses or not. We just interpret whether the person has a license or doesn't have a license. That's the only rule of the court there. Now, I will say what you're referring to is the ability of the Department of Licensing to suspend licenses for the failure to pay child support as
It's
ordered.
government support.
What's that?
It's not child support, it's government support.
Okay, well, it's called child support. And that's what it's, you know, if you look on your driving record, you have one of those things there that says, it says failure to pay child support. I understand there's a different way of looking at it. But it is not directly related to driving. I get that, but the legislature made that. They thought, how can we leverage people to pay what a court has determined they should pay for the support of their children? And they decided that one good way to do it was to leverage the ability to drive. So that's what the legislature decided to do. They created the law. Nobody has determined that law is unconstitutional.
A lot of people have, but they haven't taken it.
Right. So
In family court, the court rules don't apply, you know that. And due process is streamlined. So your driver's license can be suspended through a court procedure where it's a free-for-all. I've seen it.
okay. Yeah. So I like I said, I understand the philosophy you're indicating. I'll just, when the case comes to me on a driving suspended charge, I look to see if your license is active or if you don't have the privilege to drive on the state. And you view it as a right. The law views it as a privilege, and the privilege is enacted if you are properly registered and insured.
Well, it's a privilege to operate a motor vehicle on the highways, but the courts have ruled, and it's in my brief, it's a right to travel by your automobile, by your private property automobile.
There's no court. Like I said, you can look all you want, but there is nobody has ever found a case that says a court upheld the ability of somebody to drive in whatever state on public roads.
Well, driving is a commercial term too.
Okay. To operate a motor vehicle in any regard.
That's even more a commercial term. Look at it.
To operate your car. No, there's no case that says you can operate your
means
car.
using a business machine
Okay.
on a public utility.
No, that doesn't. Operate means I'm operating my computer. I'm operating
That's a colloquial.
my pencil.
That's a
Okay,
colloquial term.
well, then you're pushing your example into sort
Look
of
at Black's 5th edition, you'll see that operate means using a business machine for gain.
okay. I disagree with that, and I don't think you'll find any case that supports that.
Okay,
So,
I appreciate
okay.
your input.
All right.
Thank you.
We'll see you on the 5th of August.
Okay.
All right.